Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to address a couple of the common problems that people face after they set up their revocable living trust and attempt to fund their trust, or more specifically, attempt to transfer their financial accounts to their trust. The issue here is that if you leave your bank accounts, certificates of deposit, shares of publicly traded stock, and brokerage accounts, if you leave them in your name, then when you pass away, even if you have a last will and testament, your survivors and heirs will be required to go through a court and attorney-involved probate proceeding when you die, because your financial institutions will freeze your accounts and they won't transfer your accounts to your heirs without the appropriate court orders that are produced at the conclusion of the probate proceeding. And most people find this probate process expensive, time-consuming, and an all-around hassle because in many estate settlements, it is all of those things. So many people, in an attempt to keep their survivors and loved ones from going through the court and attorney-involved probate, will establish their own revocable living trust, transfer those assets that would be required to go through the probate if they were in your name when you died to the trust, with the idea that assets that are already titled in the name of your trust when you die don't go through this government oversight probate process when you die. In your trust instrument that you created, you will have designated someone called a successor trustee who will have the immediate ability and authority after you die to transfer your trust assets to the trust beneficiaries that you designated in your trust instrument. So creating this living trust-based estate plan in many instances can save tens of thousands of dollars of probate expense that would otherwise be paid if the estate went through probate. And it can save months or years of probate delay if your survivors have to go through the court process before they can receive their inheritance. Sounds easy peasy. Well, in many cases, it is, so long as everything is set up right and all of the third parties that need to cooperate with your plan do cooperate. But sometimes things aren't so clean, particularly when you start the process after you've signed your trust of transferring your financial accounts to your trust. So I'd like to address two complications that people face after they form their trust and attempt to transfer their financial accounts to their trust. The first snag that people can run into is when their financial institution doesn't offer trust accounts. As we move into the year 2024 and beyond, this isn't a common problem because the overwhelming majority of financial institutions realize that trusts are really common and that their customers are demanding the ability to move their accounts from their individual name to their trust name. For example, John Jones will want his accounts retitled from John Jones to John Jones as trustee of the John Jones Living Trust. But if your financial institution says, we won't transfer your account to your trust because we don't allow our customers to create trust accounts, you're likely to get somewhat frustrated. So while I'm not picking on any one particular company, there's one financial institution that was just recently brought to my attention that doesn't allow its customers to open a trust account. So I looked into it. And if you look at the FAQs, frequently asked questions, on the website of the financial institution Marcus by Goldman Sachs, you'll see the question in the frequently asked questions: can I open a trust or custodial account? And their answer in the FAQ is, I quote, "At this time, we do not offer trust or custodial accounts." A custodial account is an account an adult sets up for a minor, and we're not addressing that issue in this video, but suffice it to say that that financial institution does not allow its customers to set up a trust account. So if you're single and you have an individual bank account or an individual investment account, or if you're married and you have a joint bank account or joint investment account at a company like Marcus by Goldman Sachs, you won't be able to transfer your account to your revocable living trust in order to avoid probate. So when you pass away, those accounts will be frozen and your heirs will be required to go through probate. Now you may be thinking, but I could avoid probate by leaving my Marcus by Goldman Sachs deposit account in my name and naming my trust as the POD or payable on death beneficiary. But as it states in the Marcus by Goldman Sachs FAQs, we only accept natural persons as beneficiaries for your Marcus accounts. You cannot name a trust or other entity as beneficiary, close quote. So this is a predicament. You see, Marcus by Goldman Sachs is marketing to the younger generation because they're marketing to people who want that intuitive digital experience. And generally, it's people in their 30s and 40s who are seeking that digital experience. at least more so than people in their 60s and 70s. But it's the people in their 30s and 40s who absolutely have to leave their accounts to a trust, because it's the people who are in their 30s and 40s who have minor kids. And those people really have to leave their estate to a trust for their young kids. Naming a minor individually as a POD or other beneficiary is a nightmare when it comes to settling the estate of the parent. When a minor individually is named as a beneficiary of an IRA or other account and the parent dies, all kinds of additional burdensome court proceedings are required, where a judge appoints a guardian for the minor child, a judge oversees the management of the account while they're a minor, and the account is dumped into the minor child's lap on the date that the child reaches the age of majority, when most 18-year-olds aren't in a position to make wise long-term decisions regarding how an inheritance should be handled. So if you create your revocable living trust and you go to your financial institution to fund your trust or transfer your accounts from your individual name to your trust, and they tell you, we don't offer trust accounts to our customers at this time, and if they say you can't name a trust as a payable on death beneficiary or an IRA beneficiary, then you're going to be in a pickle. You should submit your durable power of attorney to the financial institution so that at least if during your lifetime you can't access your accounts, your power of attorney agent will be able to do so for you. But if you need your accounts to go to a trust when you die, either because you have minor kids or you're in a blended family situation that warrants leaving accounts to a trust, you'll likely need to consider whether you want to keep your accounts at that financial institution or move them to another financial institution that is more estate planning flexible and estate planning accommodating. Again, not a real common situation where a financial institution flat out refuses to allow trust accounts and does not allow trusts to be beneficiaries, but you need to know that the possibility is out there. Now, a second and much more common trust funding dilemma is when you create your revocable living trust and you go to your bank to retitle your bank accounts to your trust, and your bank says something like, sure, we'd be happy to help you retitle your bank checking account to the name of your trust, but you'll need to open up a new trust account with a new account number. And then you'll need to close your existing checking account that's in your name and transfer all those funds to your new trust account, which has a new account number. But the problem with that is if you're like me, you've got all kinds of direct deposits and automatic withdrawals that are going into and out of your checking account. And if the bank is requiring you to operate your trust checking account out of a new account with a new account number, that's going to mess up all your automatic deposits and withdrawals. Now, some banks and brokerage firms will permit you to retitle your accounts to your revocable living trust without needing a new account number or a new account. This is ideal. And even if your brokerage firm requires you to close your individual or joint brokerage account and open a new living trust brokerage account, it's probably not that big a deal because you don't have any or many automatic deposits and withdrawals going into and out of your brokerage account. It's just your checking account that can be a headache when you have to operate in the future out of a new trust checking account with a new account number. Perhaps if you really don't want to close your checking account in order to operate in the future out of a new trust checking account, and I can't blame you if that's the case, then perhaps you'll do what many others do. Add an authorized signer to your individual checking account so that they'll be able to transact your checking account for you in the event of your incapacity, and perhaps if your bank permits, you could designate your revocable living trust as your payable on death beneficiary. And then when you pass away, your successor trustee of your living trust can present a death certificate to your bank, and they'll close your checking account and remit payment to your trust. Your successor trustee then can turn around, deposit that check in a trust account to be distributed to your trust beneficiaries, all outside of the court and attorney involved probate process. So the moral of this story is your living trust-based estate plan is not complete when you sign and get notarized all those estate documents like your living trust, your will, your power of attorney, your healthcare legal documents. You're also going to need to work with your financial institutions and their policies to set things up so that if you get to a point during your lifetime where you can't sign your name, handle your accounts, and otherwise transact for yourself, you'll have things arranged in advance so that you make it easy for your trusted loved one, whether that's your living trust's successor trustee, your power of attorney agent, or someone who's an authorized signer or has full authority over your bank accounts, brokerage accounts, and any other financial or retirement account you own. And you'll also need to ensure that your financial accounts are set up so that it's easy for the successor trustee that you designated to distribute your accounts to your trust beneficiaries when you die outside of the court and attorney involved probate proceeding. And since each financial institution has their own, quote, policies regarding how they deal with ownership of accounts, trust account creation, account numbers, beneficiary designations, powers of attorney, along with payable on death and transfer on death designations, I find that you just need to work through these issues with your financial institutions to wind up with a solution that's not going to put you, your estate, or your surviving loved ones through the ringer. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me where you'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through our national estate planning law firm, America's Estate Planning Lawyers. Now go ahead and have a great day.